Welcome to Video 2. In Video 2, we will discuss the basic framework of legal analysis involving forming a contract, interpreting the contract terms, analyzing how the parties acted between the time of forming the contract and the time the performances were due under the contract, whether a breach of contract occurred or performance was completed, waived, excused, or modified, and what remedies for breach of contract are available, as well as other cases, such as if the contract fails to be enforceable or must be rescinded, that is, cancelled for some reason. Slide 2. To form a contract requires at minimum 3 elements. An offer by an offeror to an offeree containing the terms of the contract. That is, what promises and performances are being articulated, an acceptance of those terms by the offeree, and proof of consideration, that each party thought about what they were doing before entering the agreement. If all 3 elements are proven factually, a contract is formed unless a special defense applies to contract formation. In Video 1, we discussed defenses to contract formation such as capacity, illegality, misrepresentation, and the statute of frauds. We will comment on these defenses here, but because they were already covered, we will move on as if none of these defenses applied so we can see what happens when a valid contract is formed. Whenever there is a defense to contract formation, we have to look to see if any part of the contract was performed already or not. If not, we can place the parties in the same position as if the contract was not formed by the formal act of rescinding the contract. Otherwise, the performance of the parties may make the remedy available more complicated. In more complicated cases, we must always look at all the facts before deciding on a specific remedy, one or more. Slide 3. In the event sufficient terms exist in the offer that is accepted by the offeree to form a contract, sometimes some terms may be left out. In certain cases, the law will fill in certain terms left out, such as order of performance. We call these rules, operation of law, rules. For example, if Bob and Bill sign a contract for Bob to mow the lawn of Bill's house and for Bill to pay Bob $100 for the mowing, the contract may not state if the mowing or paying comes first. In such a case, to save the contract, the law implies the longer performance goes first and the shorter performance goes second. In this case, Bob will mow first, and Bill will pay after the mowing is done. The reason is mowing takes longer than paying, so mowing goes first. In those cases where the time of each performance takes roughly the same time, like selling a baseball card by the seller and the buyer paying for the baseball card, such performance, tendering the card and paying for the card, takes place at the same time. The law calls this framework concurrent performance. Slide 4. When parties have a valid and enforceable contract and each party to the contract performs their duty under the contract correctly and completely, those completed duties are then discharged. The contract itself is discharged when all parties to the contract have completed their performance correctly. But if a problem arises, such as a performance being impossible, the impossibility itself may discharge not only all duties of performance but also the entire contract or parts of the contract affected. If you pay to stay at a hotel on the beach next summer and a hurricane destroys the hotel this winter, your duty to pay for the hotel room and the duty of the hotel to provide you a room are both discharged due to impossibility of the hotel to provide the room due to the destruction of the room by the hurricane. In a separate case, sometimes a party does not wish to perform the contract duties before the time arises to perform. When a party refuses to perform a contract duty without cause or reason justifiable under the circumstances, we call this refusal to perform an anticipatory repudiation. In the case of an anticipatory repudiation, the party who did not breach the contract may sue immediately for breach of contract, encourage the other party to perform, or wait until performance is due and then sue for breach of contract. These concepts of anticipatory repudiation, impossibility, and complete performance are legal words that describe simple but key concepts in contract law. Slide 5. When an actual breach of contract occurs, we have to classify the type of breach involved. First, we ask if the subject of the contract is covered by the common law or commercial code. The common law recognizes 2 types of breach, major breach and minor breach. In the case of a major breach, all of the duties of the non-breaching party are discharged. For example, payment obligations or other duties to perform. If Bob has to pay Bill to paint his house before painting begins, that failure to pay is a major breach. As a result of non-payment, Bill does not have to paint the house, and his duty to paint is discharged. Let's change what happens with a new example to understand minor breach. In the case of a minor breach, the degree of failure to perform is small. For example, if Bill failed to paint a very small area of Bob's house, say 1 square foot in the rear of the house near a bush, that breach is a minor breach. Bob still has to pay Bill for painting but may subtract a small amount of money to offset the failure of Bill to paint that small area. Major breaches and minor breach classification systems belong to the common law. In the event of a breach involving a contract covered by the Commercial Code, for example, a contract for the sale of goods like tomatoes or apples or car parts, there is no minor breach possible. Instead, the Commercial Code declares any breach, large or small, to be a breach of contract violating the perfect tender rule. Under the perfect tender rule, the performance of the buyer and seller must be perfect. Any failure allows the other side not to perform. Literally stated, if a seller sells you 1,000 eggs and one egg is broken, you can reject all 1,000 eggs, broken or not. You do not have to pay for any egg. That completes this section here. Slide 6. There are many types of remedies for breach of contract. But before applying a remedy, we must discuss the duty to mitigate rule. The duty to mitigate rule, otherwise known as the avoidable loss rule, requires the non-breaching party to avoid any losses due to the breach if possible. That is, neither buyer nor seller can make the damages from the breach worse. Remedies for breach of contract can be legal or equitable. A legal remedy, such as compensatory damages, may include expectation damages. If you contract to buy a computer for $1,000 and the seller fails to provide that computer to you, and you must pay another seller $1,200 to buy the same computer, the breaching seller under expectation damages must pay you the $200 difference. You do not get a free computer and must still pay for the computer, but the price will be $1,000, not $1,200, given contract law protects the price you pay under contract. Remedies can also be equitable, such as specific performance. Under specific performance, a court may order a breaching party to actually perform the contract. For example, if you buy a vase for $1 million and there is only one type of that vase in the world, if you pay the $1 million to the seller and the seller does not provide the vase to you, you may sue for breach of contract. A judge can then order the seller to turn over the vase to you under the equitable remedy of specific performance. Slide 7. That completes this audio lecture. Thank you for participating. We look forward to working with you again.